First off, this morning we have to deal with the issue involving the removal of a juror. A few days ago, I received a complaint from a member of the public indicating that a juror had engaged in improper conversations with parties not associated with the case. I communicated and provided a copy of the communications to the defense counsel. After court, we then met with the juror on the record, and the juror denied discussing the case with anyone not on the jury or with anyone on the jury. She provided information that led us to the court to contact the persons that she was suspected of having conversations with concerning the case. Those individuals were interviewed and provided an affidavit regarding the contact that the juror had with them. We then also brought those two individuals in and had a hearing in chambers on the record in the presence of counsel yesterday. In which both of those individuals waffled on the nature and the extent of the contact. They also provided a recorded interview, or the state provided a recorded interview with the jurors, and I reviewed that interview last night. So the juror has had contact or discussions concerning the case with at least 3 individuals. And though it does not appear that the conversations were that extensive, it did involve the juror offering her opinion regarding evidence received up to that point in the trial that the conversation took place. And in order to preserve the integrity of the process and the interests of both the state and the defense in a fair trial, that juror will be removed and replaced by another juror. I will make a part of the record under seal because of maintaining the confidentiality of the identity of the jurors. I will place under seal the recorded interview, affidavits received, and both discussions with counsel have taken place on the record, and all of that will be made a part of the record in the case. And we'll bring the juror out to inform her that her services will no longer be needed. We will then replace her with an alternate juror. Any additional comments by the state or the defense?
Not from the state, Your Honor.
Your Honor, we do not accept from your ruling.
Yes,
I've sat through everything you sat through, and it's muddled, but we would defer to your judgment. However, I think it's important for me to note for the record that the interviews of these 2 people were done by SLED agents, one of whom was named as a witness in this case, and the other who was listed in the notes as being one of the investigating officers. Just to note that, again, SLED has made another bad judgment in this case. I'm not accepting from your ruling.
Yes.
I'm just pointing out that this is just a continuum of a calamity of errors. Thank you.
And the court has not had any discussion with any SLED agents concerning this issue. And all the inquiry by the court has been directly with the suspected parties involved and with the juror. And this is a matter that this long trial with the intense publicity is certainly it would be certainly difficult for any individual to not have some exposure outside of the courtroom to information concerning the case, and to also be tempted to engage in discussions with others. But it is improper, it is contrary to my instruction to the jury daily, multiple times per day, and this juror unfortunately violated that order. So if you will bring out juror number 785. Yes. And sir? He's gone? Let's make sure she brings everything with her. She will, I'm sure. Tony. Good morning. Yes, ma'am, up here. In your normal spot's fine. If you just remain standing for me. Good morning. You doing okay today? All right. I have, as you know, we've had some discussions with you over the past couple of days concerning indications of conversations with a few folks not on the jury concerning the case and expressing some opinion about the case. I have reviewed everything, including statements given by individuals and recorded interviews, and concluded that despite my order to not discuss the case with anyone, that intentionally or unintentionally you've had some discussions with some folks not on the jury, and which is going to require me to remove you from the jury. You have been a by all accounts, great juror, and smiled consistently and have seemingly been attentive to the case and performed well. And I'm sure that with all the time you've invested in it, you probably hate not to continue, or maybe you're ready to go. I don't know. But I certainly want to thank you for your service. I'm not suggesting that you intentionally did anything wrong, but that in order to preserve the integrity of the process and in fairness to all the parties involved, we're going to replace you with one of the other jurors. Have you brought everything that you have outside of, you left some stuff in there? What do you have in there?
A dozen eggs.
Say it again?
A dozen eggs.
A dozen eggs.
One of the other jurors brought in eggs for everybody for
Oh,
the farm.
okay.
Eggs in my purse and got water.
All right, well, you're going to leave the eggs? You want to leave the eggs or take the eggs? You're going to take the eggs. So, Mr. Bales, can you retrieve from the jury room her dozen eggs, her purse, and what else? And a bottle of water. If you can get those things from the jury room. As you know, the identity of the jurors are confidential, not known to the public, and the reason you are still where you are is that cameras are not allowed to videotape the jurors, and we have operated by juror numbers throughout the process, and we'll continue to do so, and your identity will be kept confidential as far as the court is concerned. And we trust that in the event you decide you want to speak publicly about this case, that you wait until after the case is over. You're not encouraged at all to do so, but you have a right to speak to anyone you want to if you decide to do so. No, I have not spoken with her today, but no, this is not related to, I know we also had some conversation was brought up concerning your ex-husband, but that's not a part of this consideration at all. This is totally independent of any other conversation that he might have had concerning you. That's not part of the order of the court. So they're going to get your things, and then once you're removed from the jury, you can't go back in the jury room. We'll have to tell them goodbye for you. Okay, all right. Well, thank you very much. Ed, you can go. Thank you. We get a lot of interesting things, but now a dozen eggs. It's certainly kind of interesting. We'll give her a chance to leave or to take her. She's gone? Okay, very good. Anything else before the jury comes?
Have we picked an alternate?
Oh, right, absolutely. When they come out, we'll need to select an alternate, and the clerk you have the remaining alternates in a box. Any objection to a blind selection of that alternate out of the box?
Nothing from the defense, Your Honor.
Juror number 254.
Juror number 254 will become part of the panel, or the deliberating panel at this point. 254. All right. Yes, sir. Mr. Griffin.
Your Honor, before the jury comes in, early in my closing argument, we have a blow-up of the photos of Maggie and Paul at the crime scene. I'm going to hold it up so that the jury can see, the audience cannot see, but I'm just notifying Court TV that please don't display this blow-up during the proceedings. Thank you.
Thumbs up, yes.
Oh, sure. I apologize.
Good morning. Yes, sir. Thank you. And good morning one more time. Day number 28. Welcome back. Juror number 254. You are now part of the first 12 jurors. We have 13. You are part of the first 12 of the panel at this time. And continuing with closing arguments, is the defense's turn. Mr. Griffin.
Thank you, Your Honor. Wow. We're at the stage of the case that's called closing arguments. I don't know why they call it argument. I'm not here to have an argument with you in any form or fashion. What I'm here to do today, this morning, is to review the evidence with you that you've heard in the courtroom over the last 6 weeks. And in reviewing this evidence, my goal is to address questions that you may have about what you've heard. And the jury system that we have, frankly, is the greatest criminal justice system in the world, because it's the only system, jury system, that a criminal defendant's fate is put in the hands of his or her peers. In this country, we don't leave the decision of guilt or innocence up to governor, to the attorney general, to the prosecutors, to the presiding judge. You, ladies and gentlemen, make that decision. And as perfect as our jury system is, there's one thing that I wish it provided: an interchange during the course of the trial between us. You all sitting there and listening to what we say, and we don't know what questions you have and what you want answered. by the same token, we may have questions of you that we can't ask. Here's my opportunity to try to answer the questions that I think you have. There may be some things that I go over that you've already decided, and I'm wasting your time, and if I do that, I apologize. I truly do. But I don't, this case is so important, I don't want to leave anything out that one of you may have a question about. I think I can probably speak to for everybody in this courtroom that there's one thing that we on this side have no question about. It's that y'all have been ideal jurors. We've been here 6 weeks, and each of you have come every day on time, and you've been very attentive, and it has not gone unnoticed, and we do appreciate you for your service. We know what a sacrifice it is, being away from your home, your work, your family, your personal obligations. Maybe some of you miss vacations. But you've been here in a 3-week trial, and here we are at the end of 6 weeks. And I want to thank you personally. I want to thank you on behalf of Mr. Harpootlian, Mr. Barber, Ms. Fox, and especially on behalf of Alec Murdaugh. In his opening statement, Mr. Harpootlian explained to you that the law governing your service requires each of you to engage in an unnatural task. In every criminal case, jurors are required to begin the process by presuming the defendant innocent. In this case, you were required under your solemn oath as we began, to presume Alec Murdaugh innocent of these charges. And frankly, as he explained, that's not natural. When you hear on the news that a crime has occurred and an arrest has been made, you feel a little bit relieved. Thank God they caught him. And frankly, I would not be surprised if some amongst you, when you read in the paper that Alec Murdaugh was charged with the murder of his wife and son, that you thought, oh good, they got him. But those opinions, and each of you, when you filled out your questionnaire, agreed and affirmed that you would leave those at the door of the courthouse, and that you would decide this case solely on the evidence. And that's what the law requires. And when we begin, the law also requires you to presume him innocent of these charges. Now, I've been doing this a long, long time, and up until the advent of instant replay in sports, it's been very difficult to explain just how to do that to jurors, how jurors can do this, apply this presumption of innocence. And if you're not as interested in sports, I apologize for this analogy, but the analogy is the instant replay. Whether you're a Clemson fan or a Georgia fan, that on a Saturday afternoon, there's a play called on the field, and then it's reviewed. And under the rules, the call on the field stands unless there's visual, incontrovertible evidence that the call on the field was wrong. We see that every weekend on sports. Here, the call on the field is that Alec Murdaugh is innocent of these charges. That's what the law requires. And that unless and until the state proves his guilt to each one of you individually, voting individually, proves his guilt beyond a reasonable doubt, then that presumption of innocence stays with him. You're not being tasked here to give your opinion in this trial. You're being tasked to apply the Constitution, the bedrock principles that protect us all from a government. And those bedrock principles are, first, you get tried by a jury of your peers. Second, that the jury of your peers begin with presuming you innocent. And third, that you will remain innocent until the government, if they can, proves to you individually, in your mind, that the person is guilty beyond a reasonable doubt. Now, the judge will give you jury instructions on what that means, beyond a reasonable doubt. But the definition has been defined that reasonable doubt is doubt that would cause a reasonable person to hesitate when making an important decision in their personal affairs, such as to buy a house, get married, any consequential decision. And you will be making, when you get this case, probably later this afternoon, you'll be making one of the most consequential decisions that you will have ever made in your life, I suspect. I don't know all of your backgrounds, but it will be a very consequential decision. And if the proof that the state has put before you causes you to hesitate, when you go to fill out that vote as you're deliberating in your jury room, each of you will have a vote. And you will have the right to vote guilty or not guilty. And each of you will write it down. And if there's any reasonable cause for you to hesitate to write guilty, then the law requires you to write not guilty. This burden of proof that we have, many of you may have had experience with civil cases. And in civil cases, the burden of proof is much lower, and it's called by preponderance of the evidence. And you may have seen lawyers or judges or watched on TV as they give a visual image of Lady Justice, who's blind and who's blindfolded, so she does not bias for one side or the other, and there's scales on Lady Justice. And those scales are the scales of justice. And in a civil case, if one party proves their case by a preponderance of the evidence, meaning ever so slightly tilt those scales in their favor, then they're entitled to the verdict. There's another heightened level of burden of proof in a civil case called by clear and convincing evidence. And the law requires things like to prove fraud or some intentional acts. You have to prove by clear and convincing evidence. And that's an intermediate level of proof. And so it's not just tilt the scales ever so slightly in the favor of the party that prevails, but you have to get sort of 3/4 of the way there. But now proof beyond a reasonable doubt is the highest standard of proof the law recognizes. And it is, you have to tilt the scales all the way to one side in order for the state to meet their burden. Now, a little bit about the verdict. You will have an option of guilty or not guilty. My friend Dick Arputlian over here he travels a lot. He's been to a lot of countries, and he frequently, he recently returned from Scotland, where he attended a jury trial in Scotland. And he tells me it's much like this, except the lawyers wear a wig, and I might benefit from something like that. But in Scotland, it runs about the same until it gets time to the verdict in the criminal case. And the jury in Scotland, where we derive our laws from, and they are given 3 options. One option is guilty. Second option is not guilty. And the third option is not proven. Not proven. Now here in America, we have combined the verdict of innocent and not proven into one of not guilty. And so when you go to render your verdict, if it's a verdict of not guilty, it's either you concluded that the defendant is innocent of the charges, or that the government has not met their burden of proof, their heavy burden of proof beyond a reasonable doubt. Now, and one of the reasons that defendants are presumed innocent and the government has such a high burden is because in criminal cases, the defendant really doesn't have the ability, doesn't have the resources, doesn't have the lawful authority to execute search warrants, subpoena documents, to prove his or her innocence. And so a defendant cannot secure a crime scene, cannot lift a crime scene for fingerprints, shoe-wear impressions, cannot secure telephones and get electronic data in the course of an investigation. So the defendant is limited on what they can do. In this case, on June 7th, 2021, Alec Murdaugh called 911, and Deputy Green, and then followed by other deputies, rolled up on the scene. And he is standing on his property. His wife and son lie dead in a pool of blood each. He's within yards of him, and he just put a shotgun down. He just put a shotgun down. And what would that look like? 90 out of 100 cases when an officer rolls up, it would look like the person who had the shotgun and 2 dead bodies may have done it, probably have done it. Certainly is someone who should be strongly considered. And all the officers in this case told you that. Deputy Ratner said, yeah, Alec Murdaugh was a suspect, but there were a lot of suspects out there. Everybody was a suspect. Fair enough. Agent Owen says, well, you know, we have a circle, investigative circle, and it starts with immediate family members, particularly if they found the deceased, the victims. So he's in the circle by virtue of calling 911. And that's fair enough. But what doesn't strike us as fair is that the next morning, on June the 8th, after the gruesome murders of Maggie and Paul, this is what is issued, a joint press release, Carleton County and SLED, that says, at this time, there's no danger to the public. At this time, there's no danger to the public. We have 2 people who have been executed within, y'all are out there, I don't know, is it 100 yards, 200 yards from Moselle Road? They've been slaughtered. And at this time, there's no danger to the public? Does that tell you that on June 8th, law enforcement had decided it had to be Alec Murdaugh? It's a fair question for you to ask yourselves. It's a question that's not been fairly answered in this trial. We know from June 7th to June 8th, Alec is a suspect and he's in the circle. And from that day forward, he is at the mercy. He is at the mercy of the ability of SLED to exclude him from that circle. They have the ability to do the forensic work, they have the ability to interview witnesses, and they have the ability to gather electronic data. And we believe that we've shown conclusively that SLED failed miserably in investigating this case. And had they done a competent job, that Alec would have been excluded from that circle a year ago, 2 years ago, but he would have been excluded. What did you hear from the witness stand? You heard from Chief Barry McCroy. I didn't know Chief McCroy until I got involved in this case, but his reputation is outstanding, and he's a consummate professional. And he explained that when he got there, he was concerned that cars would be pulling up and there were some tire tracks that were not being protected, and that they could have evidentiary value. And then you heard from Mark Ball, who had a conversation with Sheriff Hill, who's another fine public servant here. And he also agreed, we've got to stop cars from coming in here to preserve these tire impressions. And it was not done. It was not done. Captain Chapman from the Colleton County Sheriff's Office, he testified about seeing other sets of tire tracks. As you had came in off Moselle Road, you probably saw where Deputy Green's vehicle had stopped right at the kennels, but then on the other side, where you saw that Alec was parked and pacing on some of these videos, that's where Captain Chapman had talked about seeing tire tracks, and he tried to track them. SLED was coming on, and then it was like a trail to nowhere. It was a trail to nowhere. Deputy Rutland talked about seeing hair in Maggie's hands, you'll recall. You didn't hear anything about the hair in Maggie's hands from that moment forward. Was it tested? Was it sent off for analysis? There was no evidence of what, if anything, happened to the hair in Maggie's hands. Was it as a result of a struggle with her assailant? Was it her own hair? I mean, we don't know the answer to that. We know they failed to take fingerprints from the feed room, and they should have. They failed to properly take footwear impressions from the feed room, or at the apron right outside the feed room. And I think that's. I don't think that's uncontradicted. The Agent Worley, who doing the best she can, did not go there to document footwear impressions. Did not do that. You heard from our expert, Mr. Zerti, what is required, and I believe Dr. Kinsey also agreed it was not done. I know Mr. Palmbach did, and both. Now I'll get to the shot angles in a little bit, but both Dr. Kinsey and Mr. Palmbach have this murderer for Paul standing on the concrete. Standing on the concrete. Whether 1 foot's in, 1 foot's out, both feet are in, but there should have been footwear impressions. But we'll never know because it was not preserved. It was not taken. The thing that has baffled us, has completely baffled us, is why did they never take DNA samples off of Maggie's clothes, her dress? Why did they never take DNA samples off Paul's clothes? They never did. They never did. And we asked their investigators, why didn't you? Well, that's somebody else's job. That's somebody else's job. It was never done. But you know whose clothing they took DNA off of extensively? Alec. And you heard Agent Zapata talk about all the different grids on her shirt where DNA samples were taken. Was Alec assaulted on June the 7th? No, he wasn't assaulted. Was Alec wrestling with the assailant on June the 7th? There's no evidence of that. So why are they taking DNA evidence off Alec's clothing in June of 2021? And there's only one reason. And it goes back to this right here. There was only one reason. Only one reason. Is that they had decided that unless we find somebody else, it's going to be Alec. Unless we find somebody else, it's going to be Alec. And I'll get into more detail about Maggie's phone. And Maggie's phone was not secured properly. Maggie's phone was, well, let me just go right into it. Maggie's phone was found on the side of the road in the morning or early afternoon on June the 8th. Whoever killed her threw that phone on the side of the road, without a doubt. Without a doubt. Alec, from the get-go, has said, you get Maggie's phone, you get my phone, and you get my Lone Star data, and you will not see my car traveling down the road with Maggie's phone, because it did not happen. It could not happen. Detective Owen, have you gotten it yet? No, we've not. We sent the black box from on the Chevy to the FBI. It was a new model. Turns out the data's encrypted, and so we haven't got it yet. Well, what about General Motors? I mean, I'll do what I have to do, whatever I can do, and so, well, you know, we're looking into it. Well, what we learned during this trial is, sure, SLED sent a subpoena via fax machine to somebody in Detroit, I believe, and whoever got it in Detroit, whether there was a number off, I have no idea what the reason was, but we do know the initial response was, we don't have anything. We don't have any OnStar data that you're looking for. There's no indication that SLED followed up with a phone call. There's no indication SLED followed up with a letter. There's no indication SLED did anything other than put it in a file. Put the response in a file. And that was it. That was it, ladies and gentlemen, until somebody watching this trial somewhere contacted somebody at General Motors and said, why don't you guys cooperate with the FBI and SLED on this investigation? And they're like, what are you talking about? So Friday, during sometime the last 6 weeks, lo and behold, here comes all the OnStar data that you got to see. And that would be great. That would be great. But for the fact that when they seized Maggie's phone, it had, they put it in airplane mode. They knew how to put it in airplane mode. Excuse me, I'm losing my voice. Let me get water. I apologize. Oh, there's pollen. Something else. They put it in airplane mode, but what you'll see, I got a photograph, is the location services were still on, meaning still pinging off GPS satellites. And the phones don't hold that much memory. They hold a lot of data, as we have learned, but they don't hold that much memory. And it writes over itself. And for GPS location services, the ping points that we see from Paul's phone on all that data, that would have been on Maggie's phone for the 7th. But for the fact that it wasn't extracted until sometime in June 16th. I think that's the date, but if I'm wrong, I apologize. But it's around the middle of June. And that ping information that we see on Paul's phone, from Maggie's phone, it goes back to June the 9th. Well, a lot of good that does. A lot of good that does. We don't have it. We would have had it had they extracted it earlier. Now, Agent Dove says we didn't have an upgraded software that would read it. It took us a while to get it. I don't know why it took them a while to get it. There's really no explanation about that. But you heard about Faraday bags. Put it in a Faraday bag. So it's not pinging against satellites, not overriding. They didn't do that. And it's lost. Had they done it, I hope we wouldn't be here. I hope, because I know it would say, because we have enough evidence in the record, and we have to go around our elbow to get to our thumb to get there, but there is sufficient evidence in the record that shows Alec Murdaugh is not driving down the road, Moselle Road, with Maggie's phone in the car, and tossed it at whatever time. When he went by at 9:08. I don't know what time they think it's tossed, but that would have gotten him out of the circle. I would hope, but probably not, because they've been so focused on him. Now, as I mentioned, Alec asked multiple times. I think the testimony was 5 times. Agent Owen, if you get this data, it will show it wasn't there. And we didn't learn why they didn't get it off Alec's phone until very recently, because you'll remember on June 10th, he gave SLED his phone. Yeah, you can copy it. Please copy it, because it'll show that I wasn't driving. Now, my phone was not with Maggie's phone at any point in time going down the road, I did what I said I did. Well, they did extract it, but what we've learned, the extraction was a superficial extraction. Not because Alec requested it, that's just what they did. Said a logical surface extraction. So they didn't go in and pull out any GPS pinging data like you see on Paul's phone. They didn't get off Alec's. Now, if Alec had not made those requests to Owen, and they are disputing that, it's one thing you can be 100% sure of, is they would have called Detective Owen up here on the witness stand during their rebuttal case to say, no, he's lying. He didn't ask that of me. I mean, they got Sheriff Smalls in here to say, I didn't give him permission to put a blue light in his car. They came and challenged whether he had authority from the sheriff or maybe a deputy sheriff to put a blue light in his car. But they didn't contradict anything he said about, I've been asking for this data that would get me out of the circle. And now we know why it took so long to get the stuff from his car. It's because it's because the FBI wouldn't go to General Motors on this event data. The FBI was up there and they bought a Suburban, they're riding it around and they're reverse engineering all these systems to try to come up reports. And then they come in here and tell you, well, it's not complete, some of it's inaccurate, but this is what we got. And during the middle of that, that's when, lo and behold, we get on started. Thankfully, we did. So then we roll into Labor Day weekend of 2021, where Alex, long-time drug problem, his financial issues, misconduct were exposed. And that made him an easy target for SLED. And I hate to say this, but the evidence is crystal clear. From that moment, he started fabricating evidence against Alec. Well, Mr. Griffin, that's an awful charge. Don't all lawyers accuse law enforcement of fabricating evidence? And I can tell you, this guy right here was a federal prosecutor, was a state prosecutor, and some of my best friends are in law enforcement. And I don't make that claim lightly. Here, what you have heard is they came up with a report that says Alex T-shirt had high-velocity blood spatter on it. High-velocity blood spatter. What's that? That means you're within feet of a shooting. And they didn't just say any shooting. It said in their report, it says as a result of Paul's murder. High-velocity blood spatter on a shirt as a result of Paul's murder. That was number one. Well, let's stick with number one. Why do I say that it's fabricated? Well, you heard Agent Zapata said we did hemotrace confirmatory blood tests on that shirt. That means there were two types of tests. There's a presumptive test, which is what they use a product called LCV that makes it turn purple where it might be blood. But it turns purple on other agents as well, including bleach, you heard. You also heard that the shirt came out of the bag wet and it smelled like detergent. Anyway, they spray it, it turns purple in places. So they think, well, that must be blood. Next thing they do at the SLED lab is they do a confirmatory test to see if it's blood. 0 for 74, not blood. That didn't stop SLED from going out and pursuing with vengeance this report. They didn't give the no blood test result to the guy in Oklahoma, and when it surfaced, they had a problem on their hands, and they were pushing it up until this trial. And you heard the testimony from the stand that they went from Mr. Bloody Shirt leading up to this trial to Mr. Clean during this trial. And they ask him, and they raise issues during the trial with Blanca, where were his clothes? No one's asking about the man's clothes that he had on the Snapchat video back in, at 7 o'clock with his son until November or so, I think is what she said. I mean, the issue of changing clothes, it was late to the dance because when they went to, as you heard, when they went to the County Grand Jury to get an indictment that you're going to be deliberating on, they told that grand jury they had an expert report that says high velocity blood spatter. And I asked Agent Owen, I said, when you went to the grand jury and when your guy gave you the report, how'd you not know, chief investigator, how'd you not know that there's this hemotrace test that says it's no blood? Well, I didn't get the email. I say it in somewhat jest, but Did the dog eat his email? I mean, how's the lead investigator in the case not get the lab report that says there's no blood on the shirt? Now, ultimately, it was produced to us, and we were raising Cain about it and saying, how can you say this on one hand and that on the other hand? And here we are with a Mr. Clean theory that he washed off after brutally murdering Maggie and Paul. He takes a hose and washes himself off and gets in a golf cart, butt naked, I guess, and drives to the house. So that's the blood spatter fabrication. The other is this blue raincoat with GSR, and do you remember that testimony? Shelley Smith, who worked for Ms. Libby and Mr. Randolph, had told SLED after September, after Alex's problems had been exposed, after she had a conversation with a Allendale police officer following an accident investigation in which she was in an accident, that on the morning, she said in here, as she told you, on Wednesday after Mr. Randolph's funeral, and that turns out to be, I think, June 16th, that Alex shows up at the house at Alameda at like 6:30 in the morning, knocking, trying to get in, and he has a blue tarp. And in this blue tarp, she lets him in. He goes upstairs with this blue tarp. He comes back downstairs. He lays this blue tarp out on Ms. Libby's retirement rocking chair in the living room, and then he leaves. And then she leaves to go to her day job. And when she left, the blue tarp was laying out on Ms. Libby's rocking chair. That was her testimony. And so SLED gets that, gets a search warrant, goes to Alameda, and they seize a blue rain jacket. They seize a blue rain jacket. And when they do, they take that blue rain jacket and they show it to just about every family member. Let me get it right quick. That they can think of, and it's defendant's 87, Doug, if you can pull it up. But they show this blue rain jacket to as many family members as they can get in contact with, and the rain jacket is, and no one recognizes it. No one sees it. No one said Alex ever worn it. No one said Paul's ever worn it. No one said Buster's ever worn it. No one said Maggie's ever worn it. Have not seen this blue rain jacket. Have not seen this blue rain jacket. One more thing about this blue rain jacket. When they did the search at Alameda, John Marvin was there. And John Marvin asked him, did you find anything? And they said, well, we found a blue rain jacket back on the property. Back on the property. And he said, well, my dad drives a buggy around, and maybe it fell off the back of his buggy. Clearly, John Marvin was understanding that it was back on the property. And then they asked him to come look at the blue rain jacket, and he was told it was found in the closet. And he said, that didn't sound right. And they never clarified it. Now here's a picture. I'm not even going to put it up, but 411 is a picture of this closet. And you can see the blue rain jacket that's just sort of folded up and stuffed down here at the bottom right. That's the blue rain jacket. And apparently right before this trial, they showed Shelley Smith this picture and says, does that look like the blue tarp you saw? She said, well, yeah, sure, it looks like it. They never showed her this. And she said, this is Appendix 87, it's on the screen. She'd never seen this. But they did GSR testing on this, and it says, whew, it's hot. A lot of GSR. Manufactured evidence, ladies and gentlemen. And then there's this issue of misrepresenting what are the type ammunition found in the shotguns at the residence at Moselle. Paul was murdered with first shot was a buckshot. Went through his chest, he was turned this way, went in here, and then out under his arm, and that was buckshot. The second shot was into the head, either depending what expert and what pathologist, it's either this way or this way, but into the head. And that was steel duck shot. I learned that you can't shoot ducks with anything but steel pellets because they don't want lead in the water. So you've got to have steel pellets. And then A.J. Owen testified, admitted begrudgingly that he had testified to the grand jury that there were 4 weapons found up on the property in the gun room, 12 gauges that were loaded, or I'm not saying 12 gauges, I'm sorry, 4 shotguns that were loaded with buckshot and birdshot. There's 4 other ones. So that matches. Well, guess what? Totally not true. That was totally not true. And he admitted on the stand it was not true. He admitted telling Alec during the interview, and he said, well, I can do trickery. And we're going to see that shortly. But and then I said, well, you trying to trick the grand jury? No, I didn't say that. Well, we walked through it, and he did say it. And he didn't remember it, and you'll remember the testimony. And I said, well, people make mistakes, don't you? Yeah, that was a mistake. And it's okay to make mistakes, right? Yeah. And you can make mistakes about time. Well, that's the most common thing people make mistakes about. It's not all right for Alec Murdaugh, who's in the center of the circle, who's not all right for him to make mistakes about time. It is not all right, according to the same investigator who says it's okay, it happens all the time. But here we go, and then Eureka. They finally get into Paul's phone in April of 2022, and they see Alec. Well, they don't see Alec. They see Cash the dog, and they see Paul's feet walking around, and they hear voices in the background. One of them sounds like Alec. And off they go. They go off and get an indictment from the Pelham County Grand Jury, relying upon high-velocity blood spatter, relying upon 4 guns having the same load, and relying upon a rain jacket that's got GSR on it, and Alex lying about being down at the kennels. Now we know, after we've been here 6 weeks, of those 4 things,
Bixby voice privacy contacts have been updated. To continue, review the updated items on your screen.
I'm so sorry. No, that was turned on. I will turn it on. What we know is 3 out of those 4 things that was presented to the Pelham County Grand Jury that you're going to be deliberating on for the indictments that return aren't true. No blood spatter, no GSR rain jacket that's ever been connected to Alex whatsoever, and there's no loaded gun. So we're left with the lie. We are left with the lie. Now, Alex lied about being down at the kennels in Almeda. And why did he lie? And that is certainly a fair question. And that's, and frankly, I probably wouldn't be sitting over there right now. He had not lied. But he did lie. And he told you he lied. And he told you why he lied. He said he lied because, I'll tell you, he lied because that's what addicts do. Addicts lie. He lied because he had a closet full of skeletons, that he didn't want any more scrutiny on him, which is the most ironic thing in the world, because depending on which day of the week, their theory is that he slaughtered his wife and son to distract from a impending financial investigation. but he puts himself in the middle of a murder investigation, and he puts himself in the spotlight of a media firestorm. That's their motive evidence, and we'll get to that. But he lied. He lied because of his drug paranoia kicked in, and he was clearly in the throes of addiction. He lied for all those reasons. But what he didn't lie for is because he was covering up the fact that he killed Maggie and Paul. That is not the reason he did it. Doug, will you play the dog kennel video, please? I'm going to play the dog kennel video. Just please listen to the voice.
Get back. There's a chicken.
Four minutes later, the state would have you to believe that Alec Murdaugh up and blew his son's brains out of his head and murders his wife after having that conversation about Bubba having a chicken or a guinea. 4 minutes later, their case wants you to believe that this is a family down at the dog kennels doing what families do. They're checking on a dog, tail, Bubba's out running around, and they're saying, Bubba, got a chicken. Now, why would Alec not want law enforcement to hear that? I mean, there's nothing on that tape. There's nothing on that tape that indicates there's any strife, any conflict, any anger, any planning, anybody being afraid, anybody running, anybody scurrying. Nothing. Maggie, Paul, and Alec down at the kennel. That's it. And their timeline is based on the fact that this automated thing kind of messed me up, but the point I was going to open this up and say, under their theory, if your phone's not moving for some period of time, you're dead right then. You could be run over in the traffic 2 hours later, but if you're not answering a text 2 minutes after you receive it, you're dead at that point. And that's their case. That is their case on time of death. Is phone stop moving, you're dead. You've heard testimony from a lot of witnesses. I would say practically every witness who took the stand, who actually knew Alec and Maggie and Paul and Buster, testified under oath how much Alec adored Maggie, she was his all. Some people describe Paul as Alec's best friend. His relationship with him was awesome. And that was unanimous. Unanimous. I want to just play briefly a clip from Blanca testimony about Alec's relationship with Maggie.
You've also, I think in multiple interviews with Sweat and other folks, described, I think the words were, Mag.
Please continue, Doc.
All. Isn't that what you told Sweat?
Yes, sir.
What does that mean? Maggie was his all.
He adored her. He loved her. He adored her.
Worshipped her. I mean, just treated her as somebody he adored, correct?
Exactly, yes, sir.
Now, this was her testimony from the witness stand. And then, in every trial, there's you hope you find, some very authentic witness, part of the fabric of America that comes in this courtroom. And we had it in this case, and it's Dale Davis. And I want you to remember what Dale testified about Alec's relationship with his family. We played Dale Davis's.
Me? When you use the phrase lovey-dovey about Alec and Maggie, what does that mean? It means they loved each other. What, in your presence, you described them as being lovey-dovey, didn't you? Yes. And tell the jury what you meant by that.
Oh, every time I always see them, I've never seen that man even raise his voice at his wife or kids. Or his wife. I've never seen him even, none of them argue. But he always, anything she wanted or the boys wanted, he would try to get it.
And what was your observation about the relationship with Paul?
They like to hunt and fish together. I mean, they drink beer together.
Okay.
That was Dale Davis. Which brings us to the question, why? Why would Alec Murdaugh on June 7th execute his son Paul and his wife Maggie, who he adored and loved? Why? The state's theory is that that it was a storm a-coming, clouds are arising, and that his financial house of cards is about to collapse, and he's about to be exposed. And because of that, he does what every rational person would do: go kill your wife and son. That is their theory of motive. That is their theory of motive. And it worked too, by the way. Because he killed his wife and son, guess what? Jeannie Seconder quit asking questions for a few weeks. Oh, in the boating case, that won't be worth anything now that his wife and son's been murdered, because he's sympathetic. Have you heard such? One thing Mr. Waters and I agree on is the best thing about jurors is you bring your common sense in here. And you use your common sense. And that's what it's all about. That's what your collective wisdom. And just collectively think, individually think, what kind of sense does that make? Alex, his financial house is a wreck. He's stealing money from clients. He's got to produce a financial statement, maybe, in a hearing coming up. And his dad goes back in the hospital that day. His dad goes back in the hospital that day, and he ultimately dies a few days later. Okay. So I get a call. Jeannie comes in. My dad's going to the hospital. Paul's coming home. That'd be a good time to kill Paul, wouldn't it? That is their theory of the case. And if you don't accept that beyond a reasonable doubt, ladies and gentlemen, I submit the verdict has to be not guilty. Because there's no reason for him to do it. No reason whatsoever. Now, you've heard a lot of testimony about these financial crimes, misdeeds, and he told you he did it. He told you he did it to support a very expensive drug habit, and none of that's an excuse, but he is an addict, and addiction is real, and addicts lie, addicts cheat, addicts steal to keep getting their drug. The evidence was permitted in this case for you to hear solely to consider, did he murder his wife and son because he had this storm a-coming, that he was going to be exposed? Is that why he murdered? That's what they say. That's why he murdered. And that's why you're allowed to consider it. Now, Judge Newman in his jury instructions will tell you that's all you can consider it for. You can't consider it by saying, man, I never knew he could do that. So if he could do that, he must be able to do the most heinous crimes in the world. Kill his wife and son, execute him style. That's a no-no use of that evidence. The only permissible use of the evidence is that sufficient provocation, motive for him to kill his wife and son? Is it sufficient motive, not provocation? And the evidence in the case is that there was no impending financial doom on June 7th. June 7th was a day which frankly was no different than any other day in the frenetic lifestyle of Alec Murdaugh. He had so many balls in the air, and even, I forgot his paralegal's name, and I apologize to her. I think Christy. She said he would come in like a Tasmanian devil. I mean, he was frenetic. And they were on to this $792,000 fee in the Ferris case, and they were asking questions with Chris Wilsey's office. But the reason they weren't concerned that he was stealing money. They were concerned that he was sheltering money, trying to hide it from the being disclosed in the voting litigation, which he was a defendant, and they didn't want any part of that. And that situation with the with the Ferris fee, as Ms. Seckinger, Jeannie Seckinger said, that was a one-off. That was completely on its own, different type conduct than all the other stuff that you heard about. That was a one-off. And what happened on June 7th? She says, I'm in his office, and he gets a phone call that his dad's put back in the hospital. And she thinks that he told her it was terminal. He may have, I don't know, but his dad is put back in the hospital. He wasn't terminal that day, but the next day he got the terminal diagnosis. In any event, she takes off her CFO hat and puts on her mama bear hat and hugs him and a friend hat and their theory is he slaughters Maggie and Paul to buy time from her investigation. That is it. That is their theory. That is their theory. And it's totally fabricated. They've got no evidence of that. There's no evidence that Maggie was on to his financial misdeeds. There's no evidence that she was about to blow the whistle on him. There's no evidence that that he had a $20 million life insurance policy on her, and that if he murdered her, that he could get out of financial bind. None of that. None of that. And I asked Ms. Secretary, how long of a delay did that buy Alec? Well, month maybe? A month? A month? That's their theory. That's what their case is built upon. And then this motions hearing is, there's a motions hearing scheduled for Thursday. It had previously been scheduled 2 other times. And it was continued at the last minute on the other occasions because 2 of the lawyers had cancer and were receiving treatments. But it wasn't sure it was going to be continued previously. Did he go murder anybody, to get out from under those prior hearings? No. This had nothing to do with it. And, so they brought the plaintiff's lawyer in. He's an excellent lawyer, and he's, like any plaintiff's lawyer. I'm going to clean his clock. I'm going to take everything he's got. That's what they all say. So then we had to bring the defense lawyer in to say, that was a negligent parenting case, and it wasn't worth the paper it was written on. Folks, that's what we are in a murder case, and that's what we're having to deal with because that is their theory of motive. But even if the financial day of reckoning was impending, if it was right there, Alec would not have killed the people he loved the most in the world. There's no evidence that he would do that. We do have evidence of what he would do and did do. And if you'll pull up Defense Exhibit 125, which is in evidence. On September 2nd, 3rd, 4th, I forget the date. This is Labor Day weekend. He gets his drug dealer, Curtis Eddie Smith, to shoot him in the head till he couldn't go on, because it was all going to come crashing down, and he had a big life insurance policy. So when Alex is at financial collapse, he doesn't go kill somebody else. He tries to end it himself. This is a natural response. You don't want anybody to do it. But people kill themselves from being exposed. They don't kill their wife they adore, son, the apple of his eye, as some people have said. That's not. That is, I don't have the adjective for that. That is so outlandish. I don't have a word for it. Totally illogical, irrational, and insane. Those are words I wrote down. For someone to kill their loved ones when their criminal conduct is being exposed. So, you can take that now. Yeah, thank you, Doug. Yesterday we heard a lot from Mr. Waters. And I've been in Mr. Waters' position. As I explained, I was a federal prosecutor for a number of years. I've been a state prosecutor, part-time mostly. And I've done his job. It's a very rewarding job. And I hold him and I hold his office in very high esteem. But there just sometimes folks just get caught up in a case, they get a desire to win, they get so intoxicated by the attention that's brought on by the case that they start sort of a win-at-all-cost approach. And I'm going to go through some things that Mr. Waters stated to you that just aren't facts and aren't supported by the facts and the evidence that you heard. And before I do that, I want to give you a cautionary statement. We lawyers aren't witnesses. I didn't take an oath to stand up here and talk to you. I have ethical obligations about what I can say and limitations under the rules, but I'm not a witness. I'm here to talk to you about the evidence. And the same applies to Mr. Waters. You decide what the evidence is. You decide. And
Further, we're going to take a short break for about 10 minutes. Please do not discuss the case. All right, thank you. You may continue.
Thank you, Your Honor. Yesterday in Mr. Waters' closing argument, he said that the evidence established that Paul and Maggie were murdered with family guns. I mean, that perhaps is his view of the evidence, but that's not a fact. In fact, the state's ballistic expert testified that the 12-gauge shot shells, as you found in the feed room, were fired by the same shotgun. That the shot shells, the things that rolled under the door, were fired by the same gun. That's all he testified to as to shotgun. Now, they have put a lot of guns in evidence here that have nothing to do with the crime. So we don't know what shotgun was used. It could have been a shotgun bought at Walmart that afternoon. It could have been a 20-year-old shotgun. But all the evidence, ballistic evidence, is shot shells were fired by the same gun. And don't know that you really need an expert for that, but that's what the testimony was on the shotgun. With regard to the 300 blackout, you'll recall that this guy, Paul Greer, testified that the cartridges found at the crime scene, and Maggie was shot with a 300 blackout, that the tool marks, it's called tool marks, that the extractor and ejector mark from the cartridges found at the crime scene matched extractor and ejector tool marks on some cartridges found at the house and some found at the driving range. Shooting range. And what he didn't say was that where the firing pin breaches is one of the most reliable indications, it did not match. No match. And he also did not compare projectiles. There was a projectile found. When I say projectile, that's the bullet. That's the bullet thing. That went into Maggie's body and broke up. But one went into the dog house and was found in the dog bed. And so they have that. And what they did not do is take that projectile and dig projectiles out of the berm where the shooting range was and compare it to see if they match. And that's the most reliable way to do it. Now, in David Owen's notes, he said that the ballistic expert can't be 100% sure until you have the gun. And you heard my cross-examination of Agent Greer, and this tool mark ballistic examination is somewhat soft science. It's come under criticism. It's what they rely upon. Not every investigative lab relies upon it. That's what they did here, but it's not gospel. It's not gospel. Another thing about the 300 blackout, he in his closing, Mr. Waters repeatedly said that Alec bought it. And I assume we're talking about the replacement. I don't know. Alec bought it. Well, Alec didn't buy it. The evidence in the record is Maggie bought it. And he kept saying it's the defendant. And it's not the defendant. The replacement 300 blackout, which frankly no one had seen Paul with it in quite some time except Will Loving on one occasion and sometime in March. It was Paul's gun. It wasn't Alec's gun. Paul's gun. At one point in time during his closing argument yesterday, Mr. Waters reenacted a shooting scenario, if you'll recall. And I'll do my best, but he stands up here and he says that Alec shoots Paul in the chest one time. And 999,999 times out of a million, that person is dead. He puts his shotgun down, and he has a 300 blackout right here. He is so smart and so diabolical that he's going to stage it so it look like two shooters. So he's got a 300 blackout here, a shotgun that he just took his son out, but his son was 1 in a million, he says. 1 in a million. Comes this way, so Alec has to put the 300 blackout back down, pick up the shotgun, and shoot Paul. Where in the world does that scenario reside other than in Mr. Waters' mind? It doesn't. It doesn't. There's no evidence to support anything like that. None. None. And the fact that he has to go to such gymnastics to come up with Alec staging a two-shooter theory, I ought to tell you, there's two shooters out there. I ought to tell you, someone to do that. Another curious point in Mr. Waters' closing argument yesterday involves Paul's intuitive talents. You will recall that Alex informed agents that Paul was an intuitive little dude, referred to him as a detective. That Miriam Proctor, Maggie's sister, said that Maggie referred to Paul as his little detective, her little detective. And particularly when it came to trying to root out whether Alex was still doing drugs. And then he just sort of left it there. Sort of left it there for you to then take it and run with it as if, oh, Paul must have found Alec using drugs. There must have been a confrontation down there at the kennel, and that must have been what happened. Now he didn't go that far in his argument, but he laid it out there for you to run with. But that was clearly the implication. And I want to tell you first, there are no facts to support that. None whatsoever. Let me add another scenario that's equally as plausible. What if Paul the detective learn the source of drugs that were being sold to his dad. What if Paul, the detective, goes to that drug source, says, cut it out. That's my dad. You're ruining my family. And if you don't, I'm going to tell on you, turn you in. And what if source is a member of dangerous drug gang?
No, that one, Chet.
Dave.
Well, the point is, there's no more evidence to support it, and there was no evidence. Those were just plausible scenarios that they were throwing out to you, and that you could think up many equally plausible scenarios. But you have to decide the evidence based on the facts that the state puts before you. Not theories, not inferences, not speculation, but cold, hard facts. Mr. Waters also said that Alex, the master liar, accused Shelley, Smith, Blanca, and perhaps another witness of lying. He never did such a thing. He never accused anybody of lying from this witness stand. Now, I've been around long enough to know that witnesses can misremember things and believe them to be true. And frankly, I'm the biggest offender of that trait in my household. I convinced myself that I remembered something accurately, and I will have an argument with my wife until she shows me photographic evidence that I'm just wrong, and that's what it takes. I mean, that happens. People misremember things. But because we point out that there was an inconsistent fact, it doesn't mean we're saying someone lied, and we never did that. We never did that. One example is Sister Marion. One example of misremembering. Sister Marion said that she spoke with Maggie about 7 p.m. while she was at Edisto, and that Alec wanted to come to Moselle to visit her father. Well, we know that her recollection is mistaken because we have cell phone records, we got FBI records, we got her phone bill, we got that shows she was in Mount Pleasant and then she was traveling to Moselle around the period of time where Sister Marion thought she was at Edisto. Did not happen. That doesn't mean she was lying about that. Absolutely not. That's just how she remembered it. And she also said that when she talked to Maggie, that Maggie was going to go over and visit Mr. Randolph at Alameda. But we know from the records that Mr. Randolph had already been readmitted to the hospital. I mean, that's in the records. And that Maggie knew it. We've got Maggie's text to Blanca, I think, in the day saying they're putting Mr. Randolph back in the hospital. We're scared for everybody and hope Alec doesn't go down to the hospital. Well, no reason I'm pointing it out. This is how Miriam remembered it. But she remembered it incorrectly. And that happens. Because we point stuff out like that, we're not saying they're lying. Now, then the same with Shelley and the blue tarp. She remembers something, we're not sure what. But the evidence clearly is, she says it was on Wednesday, June 16th. And we got FBI cell phone forensics, we've got records, and we got testimony that Alec is in Somerville. Spent the night with his in-laws, the Branstead on Tuesday, and he stayed there toward the end of the week, and then they went to the mountains at Kiowee. So Alec could not have been knocking on the door of the Alameda house on the morning of June 16th. And Barbara Mixon came in and told you that she relieves Shelley. Shelley works all night, leaves, and goes to work at the school district. Barbara Ann comes in at 8 o'clock and relieves Shelley. And as Shelley recalled it, as the tarp was laid out when she left for work. Barbara Ann came in and said, I didn't see it. No time during that week that when I worked was there a blue tarp. Shelley remembers something, but she's not a blue raincoat, and it's certainly Alec could not have come over there on Wednesday. Now Shelley also says that he spoke to me about times, and that bothered me. I called my brother. We're not disputing that. But what she didn't say is Alec told me to say I was here in 45 minutes or things like that, and And frankly, it doesn't make a lot of sense, because Alec kept saying, you get my phone records, you get my phone records, and you'll know exactly what time I was when I was there. And I'll get to this a little bit more in a moment, but Mr. Waters keeps talking about, oh, he's hurrying to get over there. He's hurrying to get over there to compress the time so that it looks like he's been gone from Moselle longer than he was. Fair enough argument. I understand his point, but that point evaporates when you're talking about how long you are at Almeda. It doesn't matter if he's there 45 minutes or 20 minutes. Does it really matter how long he was there? Now, I guess before you had the OnStar data, they could be saying, oh, he said he was there 45 minutes, but he was only there 22 minutes, and he spent the other 10, 15 minutes traipsing through the woods, burying bloody clothes, and getting rid of murder weapons. Well, we may have heard that in this trial, had we not gotten the OnStar data from General Motors in the middle of the trial, which shows conclusively he drove over there and he drove straight back. Another small point, he said there's biological material on the Polaris. I don't think that was ever tested. It certainly looks like it. But what we've learned in this case is things aren't always as they seem. They thought they had blood on the shirt. Turns out there's no blood on the shirt. And this biological material showed that Maggie was running toward her baby. Now, I don't know that there's any evidence which way Maggie was running or what she was running to. There's not. I mean, it's a fair inference, and everyone who knows Maggie would know that's what she would do, and we're not disputing that would be her mother instinct. And did that probably happen? It probably did, but it's just to state it as a fact. There's no evidence of that. Now, one thing he also said, the cell phone backlight turning on. And I don't have an Apple phone, but so here's the issue, and mine won't do it because I don't have an Apple phone, I don't think. But if you take a phone flat and pick it up, light comes on, and why is that important? Why is that important? Like I say, and I'll probably turn this phone off. And if I'm making a point that you all know the answer to, I apologize, but it's important that you do know the answer to why this is important. It's important because now that we have the OnStar data, we know Alec drove his Suburban by the spot where Maggie's phone was found at 9:08. Now, there's probably some seconds in there, but 9:08. And we know that her phone is in the woods at that point. So the question is, did Alec throw it out the window at 9:08? And the answer is, no, he didn't. Because if you throw it out the window, at a minimum, the display light's going to come on. At a minimum. And when that display light comes on, it registers. These phones say a lot. I was lesson learned in this case. It registers in this Knowledge C database, and it says display light on, and it has a time that the display light came on. Well, on Maggie's phone, the display light does not come on at 9:08. Okay? So, means Alec didn't throw the phone out. And yesterday, Mr. Waters says every single expert testified that the backlight comes on and sometimes it doesn't when the phone is raised aggressively. That's not true. Only one person testified to that. And Mr. Murdaugh, who, over the weekend, he works for Charleston County Sheriff's Department. I don't know why they didn't get Slatty to do it, but he says, apparently he got a phone similar to one that Maggie had, not Maggie's phone, had software, not the same version as Maggie, and he spent all weekend throwing the phone on the ground, see what would happen. Or many hours of the day throwing the phone on the ground. And he comes in here and says, hey folks, sometimes the light comes on, sometimes it doesn't. Well, our expert, Mika Sturgis, says it comes on. It comes on. That's what we're talking about. That's what we're talking about. But folks, we wouldn't even be having this discussion if they had secured Maggie's phone and not allowed and put it in a Faraday bag so that the GPS coordinates on the 7th would not have been overwritten. And they were. So now we got a guy down in Charleston throwing a phone around all weekend. Because they are desperate to prove Alec threw the phone out when he went by the ring. They got no evidence of that. In fact, the evidence is the contrary. He did not. And the evidence supports everything that he had said from the day he had that interview, or a couple of days. You get the OnStar data, you get GPS data, you get my GPS data, and you'll know I'm not traveling with her phone. Never got it, wrote over it, and now we've got a guy tossing a phone in an office. Doesn't even work for SLED. Not every expert says that. The guys even said that's not his area of expertise. So, if I fit all. Oh yeah, the last one was about me. Mr. Waters says that I did an HBO interview in November 2022, and he references some things I said in the HBO interview. Well, I didn't, and he knows I didn't. It was testified about. There's an HBO special. I am on it. I'm not telling anybody to watch it, but that was filmed back in, I don't know, spring, summer of 2022. I'm well before he was charged with murder. I'm not on TV talking about his murder charges, but he wants you to think that, and I don't know why. And I took a little bit of offense to that. I really did. And we object. So he will. I was not being interviewed.
Objection's overruled.
Not being interviewed in November of 2022. Not. So I've asked why. They can't answer that. They don't have an answer as to why. Now how? How could Alec, in the time period we know we're going to get to it, but how could he have butchered Maggie and Paul without leaving a trace of evidence within a matter of minutes? How? We went from why, now how. And the answer to the how is he couldn't. But this is the wrong question to be asking yourself. Because the question that you are tasked with answering is, has the state presented evidence that proves beyond a reasonable doubt showing that Alec butchered Maggie and Paul without leaving a trace of evidence, all within a matter of minutes? In a matter of minutes. Have they proven evidence? Do they present evidence of that? Proof beyond a reasonable doubt. He was able to make bloody clothes, bloody guns, who knows how much, whatever, disappeared in a matter of minutes. Without leaving a trace. Without leaving a trace. Of course they haven't. A reasonable doubt is doubt that causes a reasonable person to hesitate in one of the most important decisions of your life. And here, there's no direct evidence of Alec doing anything other than he's at the kennel, 8:44, and it's just pleasant family talking about Bubba the dog getting a chicken. So the state's trying to weave this story of his guilt based upon circumstantial evidence. And the judge will charge on circumstantial evidence, and I have no dispute with what the state put up here yesterday, because that's the law, and you're going to get it. He's going to give you the written document with the charge. And you will see in there that when they rely upon circumstantial evidence, it's as good as direct evidence, but there's some things that it has to do to be as good as direct evidence. And what it has to do, the circumstantial evidence, is that the circumstances must be consistent with each other, and when taken together, point conclusively to the guilt of the accused beyond a reasonable doubt. That these circumstances portray the behavior of a defendant as suspicious The proof has failed. That's circumstantial evidence. So what are the circumstances that the state relies upon? Well, he was at the kennel at 8:44. Paul last used his phone at 8:48. He replied to a text with a friend about a movie recommendation. Maggie's phone locked for the last time at 8:50. Actually, it's 8:49 and 50 some odd seconds, but 8:50. But, however, her phone recorded significant steps around 8:55, and we're going to see that. And her phone tried to activate the camera at 8:55, and it registered an orientation change at 9:06. And I think you pretty much understand an orientation change, but when the phone goes from landscape to portrait, or this is beats me, but goes from that to that is an orientation change, and the phone will tell you. So it did that at 9:06. And they've got 300 casings, the extractor and ejector markings matched with casings found around the house and shooting range. So that's pretty much it. And then of the circumstantial evidence of his guilt. Now they want to say, well, he lied about it, so it's consciousness of guilt, but I'm talking about what evidence they have, put all the circumstances together, prove he shot and killed Maggie Paul, and that's pretty much it. And how have they established the time of death here? Solely on cell phone use. Solely on cell phone use. And using the phone or not using the phone doesn't dictate or define whether you're dead or alive. I mean, I'd say most everybody in this courtroom does not have their phone with them right now. Under the state's theory, as I mentioned before, if they die while they're not using their phone, then they're dead the moment they stop using their phone. That's what they have here. That is their case. There are a number of reasons that Paul would stop using his phone. First, so I got two testimonial clips, one from Rogan. Remember Rogan Gibson? If you'll play that quickly, Doug. This is Rogan testifying about Paul's phone. You asked a little bit about Paul's cell phone usage. He was on it a lot.
He was on it a lot, yes, sir.
Yeah, and did it better get down?
Okay, all right. What is the objection?
Not showing the witness, showing the defendant while the witness is testifying. I think the testimony was.
What's the legal basis for the objection? All right, Mr. Griffin.
It's a clip from the live feed of this trial, Your Honor. I can't control who is being depicted, but it's my voice asking Rogan.
Been in trial how many weeks?
6 weeks.
All right, so we're not going to replay the trial.
That's right. That's a clip of a few seconds.
I sustain the objection.
All right, take it down, Doug. So you will remember that Rogan said that when Paul's phone, and by the way, if you don't remember and you have questions about it, when you're in jury deliberations, you can always ask to have testimony replayed for you through radio. John, can we play the audio without the video?
You're asking me,
Yes.
What can you do? I rule on objections.
Can you play the audio then, please?
You asked a little bit about Paul's cell phone usage. He was on it a lot. He was on it a lot, yes, sir. Yeah, and did the battery get down low pretty regularly? Yes, he would let his phone die sometime, or he would lose it. Well, and when it would get down low, did he have a habit of not using it to try to keep him going all the way out? Yes, I have seen that happen before. And have you done that yourself? Yes, sir.
All right, and so you'll know from the photographs and the evidence in the case that Paul's phone was at 2%, and it was on low power mode at the time. He was texting this friend of his about a movie recommendation. And then can you play the audio only of, you remember Nate Tootin, and he testified about Paul putting the phone down when he was working around the kennels.
And how would you describe the relationship between Paul and Alex?
They had a really good relationship.
Would you say that Alex?
I don't think that's the right clue. The so there's Mr. Tootin testified that when Paul would work, he would put the phone down, forget where it was at times, and that it was pretty common for him to put the phone down at the kennel so he wouldn't get it wet. And you recall Dale Davis, they brought him to the stand. I think they brought him to the stand to make it seem like the hose was unraveled and then it was used and put back. And we know from the video, and you can see it again, the dog kennel video, we pointed out the hose is on the ground outside Cash's kennel. And Mr. Davis says, yeah, that was not how I left it. Someone had put it down. And then I'm going to show you right here. Doug, can I have the Elmo, please? Ladies and gentlemen, you'll have back in the jury room State's Exhibit 503, which is a picture of the dog kennels from the murder scene. And what I'm pointing out on top of these two kennels are dog beds. You'll see Exhibit 503. The dog beds are up here on top. And you recall Dale Davis says that when you clean out the kennels, hose it down, you put the dog beds on top. On top. So it's pretty clear from these photos, this photo, that Paul and or Maggie had sprayed out those dog runs and put the dog beds on top, and put the hose away. Alec testified that the Bubba and Grady had on collars, and we see the collars in State's 45, and so their collars hanging here, but their collars hanging here, and then there's collars here, and the dogs don't have collars on them in the dog picture. So it's a fair conclusion that after Alec left, when he said he left, that Paul puts Bubba up, Paul puts Grady up after cleaning out the kennels, and then he goes back into the feed room to get his phone where he was confronted. Or sometime later it happened. I don't know. But they were relying upon cell phone usage for time of death. The coroner said he did the armpit test, which is no test at all. It's just a guesstimate. Can you pull up in evidence? Now I want to talk about Maggie's phone and Defendant's Exhibit 158, please. So this is Maggie's phone timeline that we put in evidence, and this is going from 8:49 to 9:07. And if you'll just walk through it, you'll see at 8:49:26, last text message read by Maggie. Okay, go to the next one. 8:49:28, backlight off. Go to the next one. 8:49:31, phone locks and remains locked until recovery by law enforcement. It was locked for the last time and never unlocked. 8:53, but on 8:53 the backlight comes on. It's being manipulated. 8:53:12, orientation to portrait starts. 8:53:15, phone begins logging 59 steps. 8:53:20, there's a Siri usage, and the testimony is you can get that by squeezing the button. 8:53:24, the orientation portrait completes, so it switches. And then 8:53:28, backlight is off. Next, backlight is on. Backlight is off again. And it's on again. Keep going. And then 8:54:34, camera use starts. It's activated by touching the camera icon or by swiping left on the lock screen. There was a question as to whether that could be from facial recognition, and Lieutenant Dove said that information resides in the Knowledge C database, but he did not look for it. Micah Sturgis, our expert, looked for it, found it, and came and told you that was not a facial recognition miss. It was from intentionally activating the phone only for 1 second. Go to the next slide. Camera usage ends. Go to the next slide. Orientation to landscape starts. 8:54:44. It ends. And then 8:55. So the point is, there's a lot going on with Maggie's phone at around 8:55. Keep going. Keep going. And then at 9:03, the backlight goes off. And at 9:04, there's a missed call from Alex. And at 9:04:23, the backlight's off. And 9:04:41, the missed call from Alex ends. So let's back up to, let's go to 9:04:23, missed call from Alex. Okay, and this was the testimony on 9:04:23, and it's important. Alex calls Maggie, and when that happens, you would her backlight was on. Go back one more. So her backlight is on at 9:03:52. At 9:04, missed call from Alex starts. At 9:04:23, and instantaneously, the backlight goes off. Now, you heard the testimony of that means when that call came in, someone pushed on the side to stop the call. Now was that done by Maggie because she was over on the other side of the workshop where we see those footprints that we heard about that were never really analyzed, and that she didn't want any noise coming through? Or was that some bad guy or bad person has Maggie's phone and stops the call? But something's going on with her phone at 9:04. I'll tell you that. And then at 9:04, the next one is missed call from Alex ends. 9:05, backlight on. 9:06, orientation changes to portrait. 9:07, incoming call from Alex. 9:06:14. Keep going, Doug. And 9:06:52. Keep going. And then at 9:07, her phone stops for good. Now, one of the things that you heard in this case is that orientation change was at 9:06 that we just talked about. And Doug, if you'll go to the if you go to Defendants 156, please. And so these are Alex steps on his phone that were registered during this time period. And if you'll go to entry, if you look at entry 28, and if you'll pull that out, Doug. All right. So 28, this is between 9:02:18 and 9:06:47. And this is the time period that Mr. Waters in his argument said was scurrying around because he took, just bring it back a little bit more, please. So can we do it so we can see the whole line? That's fine. So that, so here we see line 28 between 9:02 and 9:06. There's 283 steps, and and he went 208 meters. So I want you to first, and so they take the position that this is him scurrying around. But if you do the math, which we haven't done here on this document, but 283 steps in 269 minutes, 269 seconds, turns out to be 1.05 steps per second. 0.05. 1.05 steps per second. Multiply that by 60, you get 63 steps per second. And if, ladies and gentlemen, this is a slow walk. 1 step per second. 1001, 1002, 1003, 1004, 1005. This is Alex scurrying around according to the state's case. And if you look at the distance in meters of the last, when he gets, I guess, to the house at 7:55 to 8:55, he goes 203 meters before it stops registering. And then one thing you will remember during this time period, between 9:02 and 9:06, at 9:06, Maggie's phone has an orientation change. Her phone has moved from here to here. But what her phone doesn't have, go to the second page. What her phone doesn't have are steps. Are steps. And Lieutenant Dove testified that, yeah, it doesn't look like anyone, that her phone is moving at 9:06, but there's no steps being registered. Alex is walking from 9:02 to 9:06. So we bear the reason that Alex is not walking with Maggie's phone. That's the timeline data that I wanted to review with you. The if you'll go to Exhibit 524, Defense Exhibit 524, please. I think it's, yeah, States 524. I'm sorry. Do you have that? So if you'll go to the slide where not 38. Do you have the whole document, or you don't? Oh, yeah, we'll drop that. Okay. Well, I mentioned earlier, and so States Exhibit 524 is all the OnStar data. You will see there that he goes by this spot at 9:08 where Maggie's phone was found, and there was testimony that he sped up after he went by there. He sped up to from 42 to 45 and went back down to 44 miles an hour when he went by there. He's not speeding up when he goes by the area where Maggie's phone was found whenever it was tossed. And then they have, a chart or slide that talks about how long it took him to get over there and the speeds that it took. And Mr. Waters was arguing to you that compressed the timeline. The faster he gets over to Alameda, it means that he's gone longer from Moselle, and it gives him a better alibi because, as you know, he's orchestrating this alibi. And so he's driving fast over to Alameda according to their theory, and we graphed it out, and he's driving, he's passing some cars, and he is, he's a fast driver. Okay, so they say, he's compressing the timeline. Compressing the timeline is what they say. Compressing the timeline. But then they say, he drives fast on the way back. Why? He's driving the same speed over there, same speed back. there's no reason to compress the timeline coming back. I mean, you'd want to be driving slow as you can to make it appear you've been gone a lot longer. I mean, he drives the same speed from Moselle to Alameda as from Alameda back to Moselle. It takes him the same amount of time. He's not compressing any timeline at all. And what's the most curious part about Maggie's phone? About Maggie's phone? What's most curious about it is Alec has her password. Alec, if he is wanting to change the timeline, when he calls her phone, he should answer her phone. When he texts her, he should reply to that text to show activity on her phone that she's still alive. If he is manufacturing a timeline by speeding, the easiest way to do it is use both phones, talk on both phones, and he did it. I mean, this whole thing about using Maggie's phone, driving Maggie's phone, throwing Maggie's phone out it's such a stretch for them to come in and try to put her phone in his hand. And then you start thinking through, why would Alec take her phone and not Paul's phone? Let's start there. Why would Alec take her phone and not Paul's phone? That's a question I don't have an answer to. It makes no sense. It makes no sense why he would take Maggie's phone. If there's something on there, he knows her password. Put it in. See what it is. We know from all this phone data, her phone was never unlocked. And he had the keys. So if he's taking her phone to unlock or to do something with it, he didn't. And so why? Why? And these are circumstances that have to be consistent with each other and have to point conclusively to the guilt of Alec Murdaugh, beyond a reasonable doubt. And these circumstances just raise more questions, ladies and gentlemen, raise more questions that we wouldn't have to be dealing with if they had just simply secured Maggie's phone in a Faraday bag on June the 8th when they got it. We wouldn't be here. So we do know from the timeline that Alec left the property at 9:07. Were they killed before he left? I don't know the answer to that. But we do know that if he was in the house when the shots were made down at the kennel, that he would not have heard them. We had decibel testing from Mr. Sutton. Now they were angry with Mr. Sutton's angle test. They were not angry, but they challenged his conclusions on a lot of things. But they didn't touch his acoustic testing. Didn't doubt that. Haven't challenged that. And so if he's in the house and shots are ringing down at the kennel, he doesn't hear them. Now, they say that sometime after 8:44, and they peg it 8:48, 8:50, because that's when Paul last responded to a text from this friend of his, but they ignore the fact that it had to be cleaned up, and I think Buster testified that takes 10 minutes at least to get the dogs in, clean up, and et cetera. And then there's all this 8:55 stuff going on Maggie's phone, but let's just take him at their theory at 8:50, after having a pleasant conversation talking about, is it a guinea or is it a chicken, and Bubba, all right, so 4 months later, let's go ahead and kill my wife and my son because I got questioned at the office today by Jeannie's secretary. Okay, that's their case. So let's run with it and see where it takes us. Well, it takes us that he leaves the property at 9:07. So from the moment, if he's got, if well, if it happens at 8:50, he's got 17 minutes. 17 minutes. He would have to be a magician to make all that evidence disappear. As you heard, under either Dr. Kinsey or Mr. Palmbach, Dr. Raymer and Dr. Kinsey, Mr. Palmbach, and Dr. Eisenstadt, either way, the shooter's covered with blood on Paul's shooting. And that's what all that testimony was about. It wasn't about trying to figure out who's got the right angles. The whole point of that is, while we ended up having to get our own experts, is to prove the shooter is covered in biological material, covered in blood, covered in everything, because of the blowback. And it wasn't until on reply that Dr. Kinsey said, oh, well, there'd be blowback under my version too. Blowback meaning blood, biological material from killing Paul. So the shooter's covered in blood. The shooter's gun is covered in blood. And that there's not sufficient amount of time to clean all that up, make all that disappear, and then call your son Buster, driving to visit your mother, who he got a call from Barbara Mixon earlier today and said your mother's agitated because your dad went back in the hospital and you might want to check on her. He goes to check on her. He calls Buster. And does he say, hey, Bus, I just blew your mom and brother up? You should see the damn mess. Are you kidding me? He calls Chris Wilson. Normal conversation. He calls his brother John Marvin, talking about his dad. And then he goes over there and he sits down with Shelley and sits on his mom's dad. And he stays there 20 minutes, not 40 minutes or 22 minutes. I don't know. The records show what time. But the fact of the matter is, he's got no blood on him. He's acting normal as every day. He is the same old Alec. Yet their theory is he just blew the people he loved the most in this world, blew him away. Now, we'll talk a little bit about the angles that Mr. Sutton did, his reverse trajectories on the shots, and I mean they're having a good time joking about the size of the figure in the pharaoh, saying, oh, it must have been a 12-year-old kid, 5'2", 5'4", and you know, let them have their fun, but that's not what the testimony was. Testimony was that the barrel of the gun has to be at that level to make the shot into the quail pen. We didn't take the measurements. SLED took the measurements. And so, yeah, could a 6'4" person get down to that level? Sure. And Mr. Sutton says that's not a natural shooting angle. Could a 6'4" person get on their knees? Sure. Shooters are in movement, and a 6'4" person is going to be moving around on their knees? I don't think so. But, you know, the most common sense thing here is there were two shooters. Because there were two guns, and as Mr. Palmbach said, one gun is high capacity, holds 10, 20, 30 rounds. And if you're going down to execute somebody, one gun's enough. Why take another gun that only has 3 shots? And Dr. Kinsey agreed with the angle coming out of the quail pen, so that the angle puts it pretty far away from the door of the feed room where Paul was killed. But it's not our burden. It's not our burden. It's their burden to prove to you, based on circumstantial evidence, that all the circumstances are consistent with each other and point conclusively to the defendant's guilt beyond a reasonable doubt. And those facts are just not consistent. Those facts are just not consistent. going to say a word about condition of Paul and Maggie, particularly Paul. I'm not going to show you any photos. But I think you would agree that it was so bad. It was so bad. And Alec, in the back of the car, with me in the back of that, you could see me on the camera, sitting there talking to Agent Owen and Agent Crow, and he says it was so bad, they did him so bad. Agent Croft misheard that and said, he said I did him so bad. And I think the evidence is, everyone who's listened to it and everyone who knows what Alex was talking about around that time says they did him so bad. And Agent Owen was in the car, and he doesn't say to you, oh, he actually said I did him so bad. I think we can put that issue to rest, but that issue points to a bigger question. What would they be saying in this trial if that conversation wasn't videotaped? What would they be saying? We know Agent Croft would be saying, he said, I did him so bad. And then where would we be then? I am grateful to SLED that they videotaped that. So that you'll hear it if you have any questions. I don't think you should, but they did him so bad. That is for sure. Another thing that we're going to clear up right now is Alec's concern for Buster. You heard that, and you heard that in Mr. Waters' closing. That in the statements that Alec made on the roadside shooting in Labor Day weekend, where he tried to arrange assisted suicide, that he told officers that there's no danger to Buster. Of course, there was no danger to Buster because of that roadside shooting, because he knew who shot him, Curtis A. Smith. He knew he was trying to get himself killed. But from that, there's going, the reason he knows there's nothing to worry about Buster is because he knows he did it. That's what was just argued yesterday. Well, Deputy McDowell, in a body cam video that's in evidence, captured Alec speaking to Buddy Hill about his concern about Buster's safety. And will you play that now, Doug? It's in evidence. I don't have the exhibit number.
Can y'all get a police officer with my oldest son in Columbia? Can you call back? No, I haven't told him yet.
Can you play that again? Because I think the...
Randy, what's not Buster? Bud, can y'all get a police officer with my oldest son in Columbia? Can you call back? No, I haven't told him yet.
Did you hear that? Can y'all get a police officer for my oldest son in Columbia? What about Buster? What about Buster? Can y'all get a police officer for my oldest son? Buddy, can y'all get a police officer for my oldest son in Columbia? That's Buddy Hill, the sheriff. And they want to come in here and tell you he wasn't concerned for Buster's safety? Once again, I'm grateful Colleton County Sheriff's Department had body cams. Now you know. You know Alec was concerned. You know Alec asked for a police officer for his son in Columbia, Buster. Now I'm almost done, I promise. But I do want to talk about Alec's misstatements about time. Alex told Deputy Owen during the interviews that, well, first, Alec's statements about time are not lies. They were just misstatements. And even, like I said, Deputy Owen says people make mistakes about all the... Agent Owen, they make mistakes about time all the time. And they do. Now, Mr. Waters is critical because Alec was wrong every time he gave a time estimate. Turns out, I think Mr. Waters is probably right about that. Whether the time period is inconsequential or consequential, he's wrong about it. And the and we had brought in, Alec had told deputies in an interview that he got home at 5 o'clock, and that's not true. That he went to work that day at 8:30, that's not true. And that and so he is just wrong on times. But what was consistent whenever he had an interview, he said, you get the records, and it will show what time I did this, what time I did that. It will all be in the records. And guess what? They are in the records. And when the records show that his time estimate was wrong, they jump up and down. The statement to Deputy Green, he says, I've gone to my mom's for about an hour and a half, and I last saw them 45 minutes. Now that I don't know. I frankly don't know if that's wrong or not. I mean, he's talking to Deputy Green about 10:30. Hour and a half from 10:30 is 9 o'clock. I mean, he left. He left at 9. He left at 9:07. But that's that. The question about what he did when he got down to the scene, and he said he ran up to Paul and Maggie, and he left his phone, and then he went back to get his phone, and then he's talking to the 911 operator, and you can hear it, and he says, I've been up to it now, it's bad. He doesn't remember the sequencing, and I don't think anyone should hold that against him. Mr. Waters gets up here and says, Maggie was running to her baby. Alec was running to his baby. And can you imagine what he saw? And is it evidence of guilt that he doesn't remember what the sequencing was in that moment? Is that evidence? Is that evidence of guilt? Or is that evidence of trauma? There's a guy that then went to get a 12-gauge shotgun, and he put 16-gauge shells in it. He knows the difference, but he didn't know that night. And I'm not quite understanding what the state makes of this. Did he not go up to their bodies? Because the forensic evidence sure speaks to the contrary. What we have is Maggie's DNA all over his T-shirt. And you heard that from Agent Zapata. We have Paul's DNA on his T-shirt. How did he get Paul and Maggie's DNA on his T-shirt if he didn't touch them? If he brutally murdered them, hosed off down there next to their dead bodies, got in the golf cart butt naked, drove to the house, changed clothes, went over to his mom's, goes down, calls 911, then searches for Whaley restaurant menu and checking emails, waiting for the police to show up. How does he get the DNA on his body? Because it's on there. Their forensic lab tells you that. Because he went up to them and touched them. And then there's a spot of blood on the Suburban steering wheel that was Maggie's. And we know that the Suburban was never down at the kennel, thanks to the OnStar information. I'm not sure that was an accepted fact until OnStar sent their stuff in, but the Suburban never went down to the kennel until after he returned back from Moselle. So we know the blood got on the steering wheel after he checked Maggie like he said he did on the 911 call. And then there's a spot of blood on the gun that he went to get. And then there's GSR. There's 3 particles of GSR on the shirt, 3 particles of GSR in his shorts and 1 on his finger. And the SLED agent testified that's consistent with transferred GSR when you pick up a gun. But really, we're back to the lie. We are back to the lie. Because that's all they have in this case, is that Alec lied to them when he last saw them. And he shouldn't have. And he shouldn't have. And he said, what a tangled web we weave once we start to deceive. And once he lied the first time, he was stuck with the lie, and he continued to lie. And he shouldn't have. He shouldn't have. And he told you, what was going through his mind. Probably wasn't rational, but he was in the throes of an addiction, and he just found his wife and son murdered. And he's being interviewed. He'd been swiped for GSR. And he does think David Owen is the guy that investigated his friend. But he was wrong. He told you. Turns out he was wrong. But I thought that's who it was that night. And he was under investigation. He was being accused of obstructing the boating accident investigation. And he's under investigation by SLED for that. And he had all these skeletons in his closet. And he was wanting to get them away from him and looking for the real killer. The state in this case has gone to lengths trying to, through a sleight of hand, convince you of this and show you that, and without convince you of guilt, without showing evidence of guilt, convince you that he murdered his wife and son because of his financial misdeeds were going to come out, which is about the most illogical thing imaginable, and there's no evidence of that. And then the state brings all these shotguns in here, and I'm not going to pick every one of them up, but the forensic evidence on these shotguns is they can't be excluded. Well, okay. They can't be included either, so you know nothing more about these shotguns than you would have the day you showed up for jury selection. Because there's nothing to know about them. Can't exclude them. Can't include them according to them, but we do know there's no blood, guts, brains on any of the guns that would have been there from the shooting under everybody's interpretation of how Paul was murdered. They want you to think that because you own guns, that you should be viewed differently. I don't know what else to make of that. I don't know what else to make of that. When this trial began with opening statements on January 25th, Mr. Harpootlian asked, why? Why would Alex execute his wife and son in cold blood? And here we are, 6 weeks later. And you've heard weeks' testimony about Alex's financial crimes, drug addiction, and lies. But after all that, the state has failed to provide a satisfactory answer to this question. Why? The state cannot provide an answer to this question because the answer is he would not, under any circumstances, murder those that meant the most to him. Your oath requires that you hold the state to the exacting standard of proof that the state must prove the defendant's guilt beyond a reasonable doubt. And when they rely solely on circumstantial evidence, these circumstances must be consistent with each other, and when taken together, point conclusively to the guilt of the accused beyond a reasonable doubt. And if they merely portray the behavior of the defendant as suspicious, you must find him not guilty. The state's evidence fails to meet these requirements. Circumstances don't point conclusively to Alex's guilt. Far from it. Mr. Waters wants you to believe that Alex slaughtered Maggie and Paul on June 7th and repeatedly lied and changed the story to fit the timeline and evidence. As it turns out, In fact, the state is the one that's been manipulating evidence to fit their theories of guilt, which changed over time from the date of these murders until yesterday. In the absence of forensic science, a reliable investigation, the guns, blood spatter, the time and opportunity to have committed these murders, you're instead left to make inferences about all sorts of interactions and behaviors. Prosecution wants you to view the evidence through the diabolical monster lens that they have tried to paint, but the law requires you to view it through the lens of innocence, where none of these things, individually or taken together, prove conclusively to Alec's guilt beyond a reasonable doubt. Up until now, you've not been able to say a single word. Can't imagine how frustrating that must be. But soon you will have the most powerful voice in this courtroom. With your words, you can let everyone know that in a court of law, only evidence and the burden of proof matters, not gossip, innuendo, opinions, and most of all, not theories layered on top of speculation. With your words, you can let the state know that they don't get to obtain an indictment by misleading a grand jury and then bring you before you a case built on theories, speculation. There are two words that justice demands in this case, and those two words are not guilty. The oath you've taken in this case is to follow the law, to follow the Constitution, and to hold the government to the burden of proof. And it requires a verdict of not guilty. On behalf of Alex, on behalf of Buster, on behalf of Maggie, and on behalf of my friend Paul, I respectfully request that you do not compound a family tragedy with another. Thank you.
Ladies and gentlemen, we'll send you to the jury room for a break. Please do not discuss the case.